versus the Department of Children and Families. Good morning.
Good morning, Your Honors. My name is Ronald Gilbert. I represent the mother who's appealing the termination of parental rights judgment. We've alleged that there was insufficient evidence to terminate her rights, that there wasn't least restrictive means. The record shows that she never abused the child. In fact, the child was taken from her when she took the child to the hospital emergency room to be cared for. And she displayed some symptoms of her mental illness. There's no question she had mental illness. There's no question that she dealt with that, including taking some inappropriate medication. But even though...
Unlawful medication. And unlawful. Like
well, again, none of that ever affected her ability to take care of this child. The child was never abused because of that.
I'm sorry?
There's nothing in the record that shows that the child was ever abused or abandoned because of what she was taking.
And is that the standard that do they have to prove that the child was abused or abandoned?
They have to show some relationship between the use of the drugs and abuse. I mean, because...
or neglect.
Excuse me?
Or neglect.
Or neglect, yes. The child was never neglected in this case. Additionally, this case comes in a strange posture because they allowed the foster parents to be parties to the action in violation of the rule. This is a bad precedent because the object of the foster parents is to obtain custody of this child. There's certainly, the court is aware of what people go through to obtain custody of very young children. And their object, as opposed to DCF, which is the best interest of the child, is to terminate...
Are they the potential adoptive parents?
Excuse me, Your Honor?
The foster parents, as foster parents, are neither here nor there. They want to adopt this child.
There's no question about that. No, their attorney, there's no question that was their objective.
The trial, or the final hearing in this case, lasted 5 days, if I recall?
Yes, it was a serial hearing.
And the judge entered an order that exceeded 50 pages.
Yes.
And are you suggesting that there's nothing in that order upon which we could base an affirmance of the trial court's reasoning and ultimate determination?
Yes, because there was never any evidence adduced, one, of that the child was ever abused, two, that any danger, actual physical danger was to this child being returned to the mother was ever set forth by any of the psychologists, any of the psychiatrists. There were just some inferences based upon inferences. Oh, I'm worried about her judgment. I'm worried that she may cross the street and not watch the child. I mean, that's not sufficient. If that was the case, we'd have a lot more terminations of parental rights.
How about Dr. Archer's testimony that ZSM was not capable, nor would ever be capable of parenting the child in a safe and appropriate manner on a consistent basis?
Based upon inference upon inference. There's never been any history that this child was ever abused, even when she was going through all this mental illness that was apparently initiated by her brother losing both his legs. And the child was never abused. The child was taken from this mother when she brought him to the hospital.
So there has to be abuse shown?
There has to be some reason to remove this child from the mother, and there has to be prospective or past abuse. There's no evidence.
Meaning what?
Prospective meaning that there's preponderance evidence that this child would be abused.
And did Dr. Archer suggest that in her...
She suggested it, but didn't give a specific enough evidence or testimony that setting forth what the abuse would be. Just some vague...
Setting forth what the abuse would be prospectively?
Yes. She said something that was insufficient based upon the record to constitute evidence of abuse. To rip this child from the mother. The fact that she didn't comply with the case plan because...
Is that significant?
Well, under the statute, it is significant, but again, this is not Russia. You're not required to do certain things.
Come on, Mr. Gilbert. Mr. Gilbert, please. We know it. Please.
Okay.
Just argue your case.
Well, our position is that the spirit and the intent behind this statute is to only remove children when that's the least restrictive means. Here, the mother was going to return to her ex-husband and her other minor child in Detroit, and there certainly is least restrictive means by having the child returned to her in that situation. The ex-husband testified he was taking her back. He was going to have her live with his house. He's got plenty of room. He would monitor her medication. And he also testified that he went to her house down here, and the house was clean, appropriately taken, so that is her daughter. And actually, talking about good judgment, The record is replete that she used good judgment in allowing her child to marry her boyfriend, who took her out of a bad scene, and now they're both gainfully employed. So she demonstrated good judgment.
Did she ever complete drug abuse treatment or attend AA and NA on any substantial or
She
consistent basis?
continued to go to NA.
No. In the record, was there evidence that she had either completed her drug treatment or was attending AA and NA on a
The
regular
gentleman from
basis?
Miami Behavioral said she completed it satisfactorily.
Completed what satisfactorily?
The program at Miami Behavioral is Enrique Suarez, I think his name. And discharged her, saying that she showed good judgment and that she complied. And she tested negative all the time. She always tested negative at those 5 hearings, which were serial hearings from April to March.
Did she not continue to refuse to complete her drug treatment program and continue to refuse to attend AA and NA meetings on a regular basis?
No, that's not correct.
That's not
I don't think the
correct.
record is correct. She refused to go inpatient because she had some claustrophobia initially at an inpatient facility, but she never refused. She went to drug treatment. And she complied with the drug treatment from Miami Behavioral.
Did she continue to test positive for benzodiazepine? Did she continue to test positive for benzodiazepine?
Not in Miami Behavioral. She did it.
Well, now, of course, over a 5-day period, I'm confident that you can cherry pick particular items of evidence that will support your position. Unfortunately for you, we must consider the evidence in the light most favorable to upholding the 53-page judgment of the trial court. Would you agree that we are required?
Yes, I would agree. However,
so I'm not asking you what Miami Behavioral said. Did not her own treating doctor testify that she had a benzodiazepine abuse problem and continued to abuse it even after she was no longer being prescribed?
Yes, she did. But again, how did that relate to any abuse to this child?
She
was using a lot more.
Mr. Gilbert, we can't both speak at the same time.
I'm sorry.
Didn't that expert also say that at the time of the hearing she was not capable of being reunified with the child?
That was her conclusion, yes.
That's her doctor.
That's her psychiatrist, yes.
Well, why?
She said she had some concerns.
Why is that?
Because it's not based upon, she said she had some concerns. She didn't set forth specific reasons why this would be a danger to the child.
Well, obviously, when you're talking about prospective harm to a child, it is to some extent or another a leap of faith, since none of us can actually predict the future with any great degree of reliability, which is why we have experts who are skilled and trained and experienced in the area to come in and tell us the pathways that might lead to their conclusion of prospective abuse and neglect. Those experts opined, and the court found them to be credible, and their testimony and data reliable. Did the court not do that?
My expert indicated that she didn't feel she was a danger to the child.
Your expert is
Dr. Polyakov.
So
right. She wasn't a danger, that she was treatable.
Was his opinion repeated or adopted by any other expert?
No.
Was it contradicted by the other experts?
Yes, it was. And again, that shows that the additional expert brought in by the foster parents should not have been allowed to testify, because it allowed, in most cases, you have one expert against another. Here we bring in a foster parent who's trying to adopt this child, and they're able to bring in an expert and actually control the case, write the final judgment, in order to terminate this child from this mother.
Why did your expert, Dr. Polyakov, say that she was not capable then of reunification? And why
at that time?
Sir?
Yes.
Why did she have concern? What were her concerns? Her concerns were for the safety and health and welfare of the child, correct?
His concerns were that she hadn't completed her treatment.
But why is that? If she's an untreated person who has a serious drug problem, regardless of what you say, who has a serious drug problem which she has not taken care of herself. Perhaps it's not her fault, but that's neither here nor there.
Well, I would
the question
disagree.
Is whether under the statute she definitely has failed to comply with the case plan. The question is whether that failure has resulted in a situation in which her continued parental relationship with the child will cause the child harm.
Yes.
Severe harm.
Right. And even though she was Baker acted twice, they both really say that she's no longer a danger. And neither doctors, any of the experts testified, never felt that she was sufficiently ill to be Baker acted, which means that she was not a danger to herself or others.
An immediate danger.
Yes. And again, the testimony of her.
You're saying that there wasn't sufficient concern to Baker act her, or you're saying that's why they released her within the 72 hours without committing her?
Yes.
That's what you're saying?
Yes.
She was Baker acted.
She was Baker acted.
Yeah, she was Baker acted,
but she was released without commitment.
Right. Right.
Aren't those
The only reason she was Baker acted, by definition, is that she was a danger to herself or others.
They thought she might be, yes.
They thought. That's why Judge... Okay.
But
somebody signed something that put her involuntarily in custody. The only way they could do that is if she were a danger to herself or others.
Actually, I think the second time she committed herself.
Right.
But again, none of this led to any abuse to the child.
Do you want to save a couple minutes for rebuttal, Mr. Gilbert? Very good. Thank you.
Again, I would object to counsel.
Noted. Thank you.
May it please the court, Alan Mishael, co-counsel for FLE's AM.
What is your authority, sir?
Excuse me?
What is the authority that you have to be here?
Florida Statute Section 39.802, subsection 1, which says any person, there's a specific formulation that we recited verbatim on record, page 106. Page 106 of the record is the last page of the amended TPR final judgment, the petition. I'm dividing my time, Judge Schwartz, with DCF counsel. I just wanted to address the foster parent issue for 2 minutes, if I may.
Okay, go ahead.
Thank you, sir. On the first day of trial, what was pending before the trial court was the joint petition for termination of parental rights filed by DCF and the foster parents. The mother verbally objected to the foster parents counsel co-trying the case with DCF counsel. The single point of law she cited was 8.210. Okay?
Okay.
Okay.
How about answering my question?
Well, the legislature
I'm not concerned about her concern. I'm concerned about my concern.
Yes, I understand.
Now, tell me why you're here.
Well, the legislature has determined that not only DCF and not only the guardian ad litem, but private people can file, any person with knowledge basically, can file a TPR petition. That, under the rule, 8.210A, a petitioner is a party as a matter of law.
In fact, the mother can file a petition against herself, can it?
As implausible as that might be, some parents seek to withdraw
their children than you might think.
Yes.
Okay.
Not only is it implausible, but it's highly implausible, but it's going to be even more implausible in the future. But
see that as it may.
And that means that anybody.
Anyone with knowledge.
Anyone with knowledge.
That's right, and that's what this legislature.
How does the foster parent have knowledge of the parents'
actions? I'll tell you. First of all, the foster parents at every judicial review have a statutory right under 39.701 to get judicial review reports that recite the progress the mother is making.
So you're a participant under the rules rather than a party?
No, sir.
You're a party?
Yes.
You filed the petition or joined in it?
We joined in it as a petitioner. The record is abundantly clear.
And what permits you to do that?
The legislature, 39.8021. It's black and white, Your Honor.
Does it say there are petitioners and proceedings before the family division, the juvenile division? They can file a complaint, correct? That is, they call the DCF and say this child is neglectful, is being neglected or abused.
Frankly, Your Honor, the system is set up so.
Where is what case has the foster parent as a participant? Party.
Now, are you asking me, is there a reported case on that subject? Well, there's a reference to it in Kingsley versus Kingsley of the 5th DCA, where they refer to the foster father filing a petition. There are several instances of people who are not DCF filing petitions, either for TPR or adopting TPR petitions or filing dependency petitions in the case law. They're not cited to the court. I would be happy to file supplemental authority if you'd like.
Well, even if you're simply a participant, the trial court has the discretion to allow you to be heard.
To be heard, but to be completely frank, Your Honor, TPR cases are closed. The trials are closed to only but the parties. So I want to be real clear. The contention we're relying on is the legislature's determination to authorize any person with knowledge
to file a petition.
I
understand.
And the same
39.802, you're saying that the phrase, or any other person who has knowledge of the facts alleged or is informed of them and believes that they are true.
That's right.
Can file a petition.
And we cite that on record page 8.
It's titled Petition for Termination of Parental Rights.
Yes, sir.
What about, isn't there a proceeding for trial?
This court, in the Sims decision, which I know Your Honor is very familiar with, the majority opinion held, I believe, if I recall correctly, that it was illogical and unreasonable to assume that a guardian who has the right to file a petition doesn't have a right to trial. That's this court's decision in Sims. I recognize you dissented, Your Honor. I respect that, but that's my recollection of the Sims case.
All right. Why don't you go ahead and speak to the merits?
If I could just follow up for just less than a minute.
This is a matter of great interest and importance to you, right?
Well, because the issue was
to the foster parent community.
I don't know about that, Your Honor. What I know is my clients have been concerned for this child's welfare from the day they got her. And what is biased in the eyes of one person may not be in the eyes of another.
Yeah, of course. Nobody denies anything. Nobody's motives are in question here. It's a question of law.
So in responding to the question of law, I just wanted to get this out before I sit down. The rules he relied on about participants, explicit, and his argument is, well, participants who are not parties, okay, when they're not parties, they still have certain rights to notice and an opportunity to be heard. Yeah. It's like a floor, a procedural floor. Right. His argument is, therefore, when they're not parties, they get this, they can never be parties. That's illogical. And the legislature and the rules make it clear that's illogical. This argument was...
And the previous rule specifically says that petitioner is a party.
Right. Now,
but this doesn't.
Excuse me?
But this doesn't.
The rules of procedure explicitly say that. Right. Your Honor, this came up as we were about to go to trial. The record in the initial brief is inaccurate. The initial brief says it came up, I think, on someday in April or March. It came up on February 4th. If you look at the February 4th first day of trial, the rule on participants says it only applies if you're not already a party. We had a pending petition before the court. That rule had no application. Thank you very much.
Thank you.
May it please the court, Karla, Perkins on behalf of the department. This is a case where this child came into the system at 6 weeks old. So from October of 2009, when the department sheltered the child who's been in the department's custody since then. This is a case where you have 4 experts testifying. You have the mother's psychiatrist who talked about the mother being inconsistent. You know, she was supposed to have monthly visits where medication would be checked and changed if needed. This mother did not comply with that. You have 3 psychologists. One of them is mother's expert.
Well, there's no question that there's rampant violations of the case law. The question is there evidence of perspective that the parental ties must be severed in order to safeguard the child?
Absolutely, Judge. And the least restrictive means actually addresses whether the
I'm not even talking about that. I'm talking about whether the basis for a termination of parental rights under these circumstances, the statutory requirement has been met, which is not only that there has been a violation of the case law, but the violation has resulted or is concomitant with a determination that it shows that she cannot be reunited with the child. She cannot be the parent of the child any longer because it's a danger to the child.
That's what the evidence proved.
What is the evidence?
The evidence proved that the evidence came out of the psychiatrists and the various people. You had the mother going to parenting. She was actually under therapeutic supervision, where you had the testimony of the person who was overseeing that therapeutic visitation. And that person testified to the fact where, despite 16 months, this mother actually has 16 months where she was being observed in terms of being able to safely parent the child. Dr. McMorris, who in the February 18th transcript, she testified that the mother failed to demonstrate appropriate parenting skills. She says that...
In what respect? I mean, what did she do? What did she do wrong?
They observed the mother with the child, and the mother could not even appropriately care for the young infant. And that is what Dr. McMorris was concerned about. She said she observed the mother becoming stressed out easily, angry, upset, overwhelmed, confused. They observed her with the child to see her behavior with the child, to see whether she could safely parent the child. Her mental health and her substance abuse come together to complicate the problem, because that's why the case came in. And, Dr. Archer testified that and the case manager also, despite the fact that this mother was supposed to be getting the necessary treatment, if she's not, the case came in actually because of her at hospital, and she did not even know why the child was removed from her. A year down the road, this mother still did not even know why the child was removed.
Did the mother take the child to the hospital, or did she herself go to the hospital and the child was seen at the same time? How did that chain of events go?
Well, it's not very, very clear, but it kind of appears that she went to the hospital with the child, and then they noticed that it looked like she was taking the child to the hospital, but they noticed, the hospital personnel noticed that there seemed to have been a problem with this mother.
So the record is not clear as to whether the mother was going to the hospital for herself or whether she was taking the child to the hospital? It
appears that she was taking the child to the hospital, and they noticed some mental health issues with the mother, and so the department was contacted. But it's 6 weeks after the child was born that the child was actually removed by the department, and the mother was given a case plan, and the case manager testified that because the mother had mental health issues, she actually went the extra mile with her. And she basically kind of held her hand to make sure. This mother was given the opportunity to go into the drug court program, where she would get treatment for both her mental health and her substance abuse issues. The mother, she went through, was qualified for it, didn't go in there. They tried to get her into a couple other inpatient programs. Mother wouldn't go to that. And the department tried to get her into New Horizons. Mother wouldn't go to that either because of the distance. Eventually, mom goes to Miami Behavioral, where what was occurring there? Mother was under court order to actually do a draw 3 times a week. Mom was not even complying with that. Mr. Sanchez testified, mom is attending Miami Behavioral, but he was not testing her on the basis that he should have, because she reported to him that she was under court order to do testing otherwise.
Well, did she have regular contact with the child, except in supervised visitation or otherwise?
She only was allowed the therapeutic visitation.
All right.
And that expert who testified, Dr. McMorris, said she could not even recommend the step down from the therapeutic visitation to supervised visitation. Mother's expert, Dr. Polyakov, he could not even recommend actually a change in the whole visitation schedule at that point of the trial.
From therapeutic even to supervised.
Absolutely. When he was asked at trial.
Did he say why? Specifically why?
Well, he wasn't very clear in the sense of, this is the way it is. Obviously from, it was a lot of, this is what he thinks, this is what he believes, he agrees with others. But he said, he was asked a specific question of where in your report do you offer an opinion to a reasonable degree of psychological certainty as to when that day will come, meaning the day when mother could actually be reunited with her child safely. His answer was, I'm not asked to predict a date, but I think my conclusions are clear that she's on the road to being capable of doing that without having the child taken away from her. On the road, down the road somewhere. You know, she could not give a date, whether it's a year down the road, 2 years down the road. The child has come into the system from 2009 October. The child's already in the foster care system for 2 years. If, you know, based on his assertion, the child could be in the system for 3, 4, 5 years down the road. This mother, unfortunately, Judge, has not been doing what she needed to do.
We know all that. We know that. But we don't. How many times have we had this discussion? This is not to punish the mother. This is to safeguard the child.
Absolutely.
And does the child need to be safeguarded by terminating her mother's rights?
Absolutely. In this case, when the department has done everything, given the mother every single referral, handheld her basically to try and put her back safely with the child. If the mother cannot even comply and make sure that she's taking her medication properly, if she cannot ensure that she herself is well.
You read an excerpt about her being angry. So at what stage was that testimony related to? When was she observed being angry, impatient, etc. with the child?
Dr. McMorris did not say that it was on one occasion. She said over the 16-month period. She has been observing her over a 16-month period. And clearly, at the time she testified, it was her looking back over that 16-month period where what changes has she seen? You know, it's the same testimony that you got from the psychiatrist. It's the same that you got from Dr. Archer. Dr. Malik was basically observing, and she looked at everything and said, you know, the mom's mental health history, plus the fact that, you know, she goes and she takes drugs at the time when she should not, shows that she is not willing to do what is needed to get the custody of her child back. I mean, you know, you can only do so much for this mother, and there comes a point where there's nothing.
Enough is enough.
Enough is enough.
3 generations of idiots are enough.
Thank you, Judge. We kindly request that you affirm.
Thank you, Ms. Perkins.
In response to Mr. Mishael's argument about participants, the reason why foster parents are participants, so if the child's not getting therapy, if the child is they're not getting the appropriate room rate or something like that, they can come in and say something, as opposed to the guardian coming in, which occasionally the guardian does from the foster parents. They should not be a party. It's a bad precedent. You're going to have all this.
Well, the statute provides for it, doesn't it? The statute provides for it.
I disagree. I don't think it provides for a foster parent to do it. A foster parent has.
So any person who has knowledge, who has been informed, any person is any person.
The foster parent has knowledge initially of what the condition of the child, and that's what the foster parent is all charged to do, to take care of the child, not to take the child away from the.
Well, listen, we're just judges. We're not legislators. We don't make the law. The statute is clear, isn't it?
I don't think it's clear, Your Honor.
Okay.
Why would the rule say that they are right?
Do you agree that the statute says that anyone with knowledge can file a petition for termination of parental rights? Do you agree that they qualify as anyone?
Do they qualify as anyone?
Do they come within the statute?
Yes, anyone is anyone, yes.
And do you agree that the rule says that the parties to a TPR proceeding include the petitioner?
Yes.
So if we combine those two concepts, that they can file and they become the petitioner, and the rule says that a petitioner is a party, then how can we change that by ruling that they should not be parties?
The argument is that it's a bad precedent.
So you're suggesting that we should...
Yes, because if you allow foster parents...
the rule or the statute...
No. Oh. If foster parents... a lot of foster parents take care of younger children because they want to...
Public policy is not our domain. That's what the legislature is supposed to do.
Why would there be a difference in the statute and the rule?
It says any other person with the knowledge of the facts alleged. The alleged are the neglect and abuse of the child. The foster parents don't have any such knowledge.
That's correct.
The next thing says, or is informed of them. and believes that they are true, that raises a constitutional question. It means that anybody who, including Mr. Mishael, who would be a fantastic participant, let alone party, in any case, who is informed about these nasty allegations and believes them to be true, they are true.
Perhaps the legislature has decided that they would err on the side of inclusion because ultimately we are talking about the safety and welfare of the child. So why not be overly inclusive? Let the court, the trial court, figure it all out at that level.
Unfortunately, this is a court. There are many, many people who think, probably correctly, that these things should not be decided as an adversary proceeding. It should not be decided by a court. However, it is. And a court, the discussion of a court requires an adversary. It requires a real conflict. It requires a case or controversy. And a person who is informed of the facts and believes them to be true should not be an interloper in a court proceeding. This is. You agree with that, I'm sure?
Yes.
Entirely.
Yes.
Okay, what about the facts of this case?
All right, facts of this case.
I'll give you one minute if you look to wrap up.
I'll give you another one.
Dr. Natamura says...
I don't care what he says.
Also admitted that these supervised visitations were 2 hours and all parents are nervous. This is a mother whose child was taken right after birth. And,
how long did these supervised...
2 hours.
No, the therapeutic visitation lasted over a period of how much? 16 months?
Yes. And Enrique Suarez saw the mother 21 times. She tested not positive 21 times at Miami Behavior.
Or did they test randomly because they were under the impression that she was being tested pursuant to a court order elsewhere?
He tested her as well as doing random tests, yes.
I thought it was only random testing under the assumption that she was being tested regularly somewhere else.
As I remember, that he saw her 21 times and randomly tested her. Also, I would point out the part of the judgment where the court, it's page 43, paragraph 25. The synthesis of my findings is no one has suggested that no one believes that the mother would intentionally harm this child. The court found that.
Of course
she would
not.
intentionally harm the child. The record, again, is that the child was never abused, even when the mother was not being adequately treated.
She was not in a position to be abused. She was kept in it.
No.
Harm resulted in a case in a different court.
Before she was brought into the system, the child was never abused. The child was never abused at the hospital.
She was 6 weeks old.
Yes, and the mother, as any other mother, was taking the child for an illness to the hospital. And then her child's ripped from her, and she's assumed to have to be go through the procedures of DCF, unrelated to the fact of whether or not she had abused the child.
All right. Thank you very much, Mr. Gilbert. Thank you all.